In a recent Supreme Court case, Justice Kavanaugh cited an amicus brief and asked, how are brokers supposed to assess driver safety, English proficiency, drug use? How are they going to do this? Marc Blubaugh wrote that amicus brief in the case Montgomery versus Caribe Transport. He joins the High Court report today to discuss this case.
This is the High Court Report with special guest Marc Blubaugh.
This case stands to disrupt America's $343 billion freight brokerage industry. I'm Ryan Weir, and this is the High Court Report. In Montgomery versus Caribe Transport, the Supreme Court must answer whether states can hold freight brokers liable when a trucking driver causes a car crash. Marc Blubaugh helps break down the briefs and oral arguments. He co-chairs the Transportation and Logistics Practice Group at Benesch, Friedlander, Coplan, and Aronoff. U.S. News named his firm Transportation Law Firm of the Year multiple times. He serves as outside general counsel to the Transportation Intermediaries Association, and he represents brokers, carriers, and shippers in cases across the country. Marc joins today in his individual capacity. His views are his own and not those of the Transportation Intermediaries Association, his law firm, or any other organization. Marc, thanks for joining. How are you doing today?
Thank you, Ryan. Delighted to be here and happy to be having the conversation.
Now, in 60 seconds, what stood out most to you from oral arguments?
I would say that the attorneys arguing these cases are masters with their craft. That's one thing that certainly jumped out to me during the course of the argument. Seeing an attorney walk up with one sheet of paper, never really needing to look at it, even if I may disagree with that attorney's position, they engage the court in a very effective way. And while it's a very solemn environment, the advocates were more conversational in certain respects than I may have expected. I enjoyed watching the justices' expressions and gestures, which probably amplified a little bit about what you could certainly glean from the transcript or listening to a recording. But the bottom line is, I'm not sure how you can sit in a Supreme Court of the United States argument and not be impressed with the United States judicial system, which is not perfect, but pretty darn good.
Was that your first time at a Supreme Court oral
It
argument?
was. It was.
Wow. Wow. That is awesome. Now, you sat in the courtroom while the oral arguments played out in real time. What key themes emerged from the oral arguments?
Yeah, I would say there were a couple of things that struck me during the course of the argument. One is that shout out that you referred to the amicus brief that I filed on behalf of the Transportation Intermediaries Association. I didn't think that counsel for the petitioner, as highly capable as he was, really answered Justice Kavanaugh's question adequately. And Justice Kavanaugh raised that theme a few other times during the course of the argument. And petitioner's response was essentially, hey, they simply need to hire quality carriers or not hire what he referred to as fly-by-night carriers, but didn't offer to define the same without specifying what a broker would need to do. He defaulted to saying, well, as long as they ask a few of the hard questions, whatever those may be, then they'll be okay. And Justice Kavanaugh pressed him, again, several times regarding those issues. When it came to English language proficiency, for instance, at least petitioner conceded, well, it presents a complicated question. But again, kind of defaulted to the notion that, well, a broker just needs to make sure that a carrier has an adequate testing program. Again, without any specificity about what does that mean? What is adequate versus inadequate? And the reality is the plaintiff's personal injury bar always takes the position that whatever a broker does is not enough. And if they do too much, then they become vicariously liable because they are controlling the motor carrier, kind of working as an outsourced compliance department or otherwise. So that's one of the themes that leapt out to me through the course of the argument. I think the second one that caught my attention was that there was much more discussion about proximate cause than I expected to be the case during the course of the argument. Some of the justices appeared to believe that rather than relying on preemption, brokers can simply rely on proximate cause principles because the broker's position relative to the accident is so attenuated. But I think that really misses the point. The F4A preempts the duty element in the first place. We shouldn't ever really get to proximate cause. And from a practical perspective, telling a broker to defend a case on a proximate cause basis is really kind of cold comfort. It almost then inevitably becomes an issue for the trier of fact, whether that's a judge or a jury, and the broker spends an extraordinary amount of time and money on that kind of a defense. So I think that's a second theme that leapt out to me. A third that comes to mind is that I think many of the justices had really good questions about subsection B1 in the statute. And that section, really, which preempts intrastate rates, routes, and services, doesn't have the so-called safety exception, which is at the heart of this Montgomery case. And the plaintiff or the petitioner in this case at least conceded that that distinction was the way that I think he characterized it was a bit anomalous, but he wasn't arguing that the legislative distinction makes any sense. And when he was pressed again on that subject, about whether he had, for instance, a brilliant way to reconcile the apparent anomaly, he came up empty. He had none. And I think that counsel for respondent, C.H. Robinson, pointed out effectively that this was kind of an unthinkable reading of the statute. And it's absurd that Congress would have wanted the states, for instance, to regulate interstate transportation, but not transportation within their own borders. And the Deputy Solicitor General, again, kind of built on that, saying, look, there is no anomaly here. If you construe the statute in the way that respondents believe it should be construed, you can kind of avoid that entire issue. So I think that was another one. I think that probably a fourth that I think about or observed was that a number of the justices and counsel placed, I think, unnecessary or unwarranted emphasis on the FMCSA's capabilities and resources. This is the Federal Motor Carrier Safety Administration that regulates the industry. And there was an effort to, I think, paint a picture where the agency is allegedly falling down on the job. And even if that were the case, it's not an excuse to shift a federal responsibility that is imposed on the federal government to companies in the private sector. I'm sure that the FMCSA, like every government agency, would love to have more resources to perform its functions, but I would surmise that the agency would contest claims that it's unable to perform its essential functions. There's lots of staff at the FMCSA doing lots of great work every single day and always trying and striving to improve. So I think those are a couple of the main takeaways, that themes that I saw emerging through the course of the oral arguments.
That was an excellent roadmap for today's discussion. I could not have written it better myself. So let's dive in here. And before we get to the legal battle, I actually want to talk about the landscape a bit, because as we mentioned, logistics operates as a multi-billion-dollar global industry. There are many moving parts, many people, stakeholders that the average person may not know about. And you have shippers, you have brokers, you have carriers. Your brief uses, or the Transportation Intermediaries Association brief that you filed, uses a travel agent analogy to help people understand the different hats that the parties wear. So help us understand the role of the players, and also how the brokers fit into the ecosystem in the years after the law was passed, but before the Supreme Court took this case.
Sure, sure. So to outline the players, we start with shippers. They are the owners of cargo who need to move it around the country from origin to destination. Sometimes they're referred to as beneficial cargo owners, but shippers is the usual term. Um, if we move to the brokers, they are, as you indicated, intermediaries. They're middlemen that arrange for the transportation of goods by motor carrier for compensation. They are hired by the shippers. If I am a shipper and need to move my goods, I may hire a broker to find an effective and efficient way to move my goods. The brokers themselves do not actually perform the transportation. They don't own trucks, they don't operate trucks. As you said, think of them as travel agents for freight. They are licensed by the federal government as well. Brokers have a license that they must apply for and obtain in order to arrange for the interstate transportation of goods by a motor carrier for compensation. So then if we move to the motor carriers, this is generally a person or an entity that is providing transportation by motor vehicle for compensation. They too are licensed by the federal government, assuming that they are performing transportation interstate. And the vehicles can range in size from small lightweight vehicles to large tractor trailers. Motor carriers have drivers. These are the persons who actually operate the vehicles that are moving the goods. They're the workforce of a motor carrier. They act under the operating authority or license of the motor carrier. And those drivers can be employees or they can be independent contractors. But either way, they're operating under the licensure of that motor carrier. And then the consignee is the party who is receiving the goods at destination, where the shipper is sending their goods from origin to that destination. The consignee is the recipient of those goods. So does that help?
It does. It helps a lot. And let me just give you a scenario and help me walk me through the
Sure.
players in this. So let's say my kid is at soccer practice and they lose their water bottle. There's a game in a few days and my kid really needs the water bottle. So I order a replacement on Amazon. Someone in an Amazon branded van delivers the water bottle to my door in 24 hours. Walk me through that chain. Who's the shipper, the broker, the carrier, the
Sure.
driver in that scenario?
So you, if you're trying to order the goods, you are the customer, you're the shipper. So
Okay.
you are in theory could be hiring a broker to contact Amazon, or Amazon, you could be contacting Amazon in its capacity as a broker, because sometimes it operates as a broker. But you'll be contacting some intermediary to say, hey, I need help. I'm not an expert in transportation. I need to get my goods from A to B. So, in theory, you contact that broker. The broker has a network of various motor carriers, one of which could be Amazon if you were contacting a third party broker. And they say, okay, well, we can arrange that. We have company relationships with companies that have these assets, that have lightweight vehicles that can move goods from A to B. And that party essentially will send one of its drivers to the warehouse, for instance, where this water bottle might be, or wherever it originates at, and then picks it up and delivers it to destination so that you have it for in time for the tournament that is coming up.
I see. So when I order on Amazon, Amazon could be the broker in that scenario.
Could be.
And then if they're also performing the delivery, they could also be the carrier.
Yeah,
Sometimes
there
they're.
are
Mhm.
many logistics companies wear a number of different hats. Amazon could be a shipper in certain respects because it might own the goods that you're
Oh,
purchasing.
yeah, yeah.
It could be a broker where it's simply arranging for the transportation of goods. It could be the carrier that's providing the delivery at the end of the day. So, with some of the larger logistics enterprises, there are many different hats that a given company can wear at any time.
I see. Okay, that was very helpful. So now let's talk about the legal fight here. And it essentially turns on two laws that interact with each other to some extent. Subsection C1 says states cannot enforce laws related to a price, route, or service of any motor carrier or any broker with respect to the transportation of property. But there's a major catch. States keep their ability to regulate motor vehicle safety. Subsection B says states cannot enforce laws related to price, routes, or services of brokers. There's no exception there. In plain English, and to oversimplify just a little bit, Congress blocked states from regulating broker services, but carved out an exception for motor vehicle safety. And the issue in this case is whether one of the issues in this case is whether that carve out exception for motor vehicle safety applies to brokers. I'm hoping that you can make sense of this language, tell us what it actually means, and how it applied in the years before the Supreme Court took the case.
Sure, sure, absolutely. So maybe if you think about C1, a little historical context is probably helpful. I mean, if we step back in time to like the late 70s, when Congress was deregulating the airline industry, Congress enacted the Airline Deregulation Act. And one aspect of that was Congress saying, look, if we're going to deregulate an industry, we want to make sure that the states don't re-regulate it. We want to make sure that they don't decide to enact laws, ordinances, statutes that might impinge and interfere with our effort to try to deregulate the industry. So they included some language very akin to what you just read, stating essentially that states cannot regulate the prices, routes, or services of airlines or air carriers. So when we move forward to the trucking industry, and by the way, that statute worked. It essentially, deregulation met its goal, and the states were prohibited from interfering with those objectives. So in the course of deregulating the motor carrier industry, Congress said, hey, why don't we use that statute? Why don't we use it as an analogical template for what we're trying to do with the motor carrier industry? Likewise, we want to, unleash that industry. We want to give them the freedom to compete with one another. So we don't want the states to interfere with that. And we're going to include similar language saying that no state can enact a law or regulation that is related to the prices, routes, or services of motor carriers or brokers, as freight forwarders are also mentioned in that statute. And again, the aim here is to create uniformity for the transportation industry through that preemption. And the form of laws, we talk about these laws or regulations, the statute is also intended, and the courts have made this pretty clear, to capture not only positive laws that a jurisdiction might enact, but also court judgments, jury verdicts, the tort body of law that any given state has. So that was the objective. And the question, as you pointed out, in this particular case is really focused on the so-called safety exception in C2, because there are a number of exceptions to the breadth of that preemption. And one thing that Congress said was, hey, we're not trying to restrict the safety regulatory authority of a state with respect to motor vehicles. And we're not trying to restrict the ability of states to do various other things. And there's a laundry list in the statute. And the plaintiff's personal injury bar argues that this exception in C1 saves from preemption claims against brokers for negligently choosing a given motor carrier that ultimately is involved in an accident. That's the thrust of it.
See, and so the parties in this case look at the exact same text. There's no dispute about whether any other law applies. They're all on the same playing field for this text, but they draw completely opposite conclusions from the very same words. So talk to me about each party's positions, and maybe you can do it from the context of the oral arguments, which you were part of, how you saw things play out in the oral arguments.
Sure. Yeah, there's the number of different threads in these arguments that are being made. But if we think about the language, for instance, that you focused on, it's all about what does the phrase with respect to mean, and what does a motor vehicle mean? And the argument that I would say, or that really the respondents in this case were advocating for is, look, if the phrase with respect to truly massively limits the scope of preemption in C1, because that's something that the Supreme Court has previously held, that the phrase with respect to does, and this is the Supreme Court's language, massively limit the scope of preemption in C1, then it should similarly massively limit the scope of the exception in C2. There has to be some kind of limiting principle here, and that the limiting principle is a distinction between a direct link and an indirect link between the state law and motor vehicles. Otherwise, you could extrapolate this, and no law would be preempted, since every relevant law has at least some kind of vaguely indirect relationship to motor vehicles. So including that phrase "with respect to motor vehicles" would be kind of superfluous. It would have no operative effect. And the inclusion of these other exceptions, similarly in C2, would be redundant because they are all at least indirectly related to motor vehicle safety, whether we're talking about, limits on size or weight of vehicles on highways or otherwise. So that's one part of the textual argument. The petitioners, on the other hand, take a contrary view of it and say, hey, you're making much ado about nothing here. With respect to should really be treated as synonymous with concerns or involves or is related to, and a state law requirement to exercise reasonable care in selecting a motor carrier must necessarily concern or involve motor vehicles, because that's the point of these laws, is to protect the public from unsafe motor vehicles. And that the Congress's choice in drafting, using this phrase "with respect to" instead of "related to," is really immaterial. It's meaningless that Congress uses different prepositional phrases in various ways. Maybe it was stylistic or otherwise, and that there's no reason to read this distinction between direct and indirect into the statute. So that's part of the kind of plain language argument component of the party's position. I think that informing that, though, is what I alluded to earlier, is B1, which governs intra-state transportation and contains no safety exception. No one argues that there's a safety exception in B1, which clearly preempts these claims against a broker with respect to intrastate transportation. So, using that as a clue as to what Congress's intent was in drafting this language, I think is highly informative. And it's also, consistent with the kind of legislative history and the understanding that at least most in the industry had about the evolution of these requirements. Because if we step back in time again to before the enactment of the F4A, we know that the Interstate Commerce Commission had previously looked at whether or not brokers should have a financial responsibility requirement. Should they be insured? Is there something beyond their broker's bond that is required? And there never has been any requirement for auto liability insurance. And Congress revisited that topic as recently as 2012 in the highway bill called MAP 21. And while it did increase the bond requirement for a broker, it never touched auto liability or suggested that brokers needed to have that type of insurance. And if you read the House Conference Committee reports in connection with the enactment of the F4A, they make it very clear that the intent of the F4A was not to expand state authority over motor carriers or brokers. They were trying to leave it unchanged, didn't grant more authority to the states. And again, before deregulation, Congress had heavily regulated motor carriers and had reduced to a certain extent the power or ability of states to do so. For instance, states cannot determine which interstate motor carriers should be permitted to operate within their state if they're operating in interstate commerce. This Counsel case makes that quite clear. And so allowing these tort claims, negligence claims against brokers to proceed forward is kind of a backdoor way of allowing states to decide what motor carriers can or can't operate in interstate commerce. And that's kind of an affront to the congressional intent, we would argue. And again, we have these ICC authorities, even in the 80s, saying, brokers aren't exposed to bodily injury claims or claims for property damage, and therefore don't need to have insurance, those types of issues. Does that make sense?
It does. And there's one thread I wanted to ask you about. You mentioned it a couple of times now, the intersection between interstate and intrastate. That's a quirk that I did not pick up on initially until I was listening through the oral arguments. So, and that seemed to have an effect on multiple justices, one way or the other. They were asking all three parties about it. So, dig into that a little bit.
Yeah, again, that statute B1, it preempts claims related to intrastate rates, routes, and services. So think, within a state, and the line between interstate and intrastate is not always clear. Some people think it's just,
Yeah.
well, if you're moving goods within a state, it must by definition be intrastate, but it could be part of an interstate move, even within, if you're doing the final leg of a move, for instance, within a single state. But B1, when it was enacted, contains absolutely no safety exception, and it's focused clearly on brokers. So the distinction that many of the justices were picking up on was, why would there be a safety exception in C2 if Congress had already said, look, you can't sue a broker if they're involved for negligence involved in intrastate transportation. Why should you be able to do it bring these claims against brokers in connection with interstate transportation? Because Congress, if anything, has a greater degree of interest in interstate transportation than it would with intrastate transportation. So that was the kind of the theme throughout. And again, petitioner wasn't really able to offer an explanation, a justification, other than saying, hey, it's an anomaly. I'm not saying that Congress makes a lot of sense in this instance. I don't have a brilliant way of reconciling this anomaly. But when the Deputy Solicitor General was asked about this, at the end, in fact, that was Justice Roberts' only question, I think, through the course of the oral argument was, hey, what's your explanation for this seemingly anomalous situation between interstate and intrastate? Deputy Solicitor General said, I don't see an anomaly here, because if you read the statute the way that we suggest you should, that C2, the exception in C2 doesn't apply, well, then it's all harmonious. Whether it's an interstate move or an intrastate move, these claims for negligent selection go to the core service that a broker is offering to the marketplace. I am arranging for the transportation of goods from A to B and selecting a motor carrier. So whether it's interstate or intrastate, these claims should be preempted. And it's yet another reason why that one should construe the statute in a harmonious way.
That was an interesting dynamic there to see how that played out. And I was wondering if Roberts was going to ask anything. And
Yeah.
I mean, he's been listening the whole time intently, and it seemed like he was just waiting for his moment to to ask that question.
Yeah.
Could you tell from the bench which justices were itching to ask questions? Justice Kavanaugh asked a lot of questions. Normally, Justice Gorsuch asks a lot of questions as well, but he only asked a couple of
Yeah.
questions.
Yeah.
So what, from your vantage point, what did you pick up on? You talked about what some of the cues you picked up from seeing versus reading the transcript.
Yeah, yeah. I mean, clearly, Justice Kavanaugh was highly engaged. Justice Jackson had a lot of questions. She felt like she needed to take advantage of that opportunity to raise her points. Everyone contributed. I mean, I was happy that each and every one of them seemed to be deeply engaged, some more than others. But it was satisfying to see that level of engagement across the board. And while I personally haven't argued before the Supreme Court of the United States, I've argued cases in state and federal appellate courts, and I have learned that it's devilishly difficult to predict outcomes and glean too
Yeah,
much
yeah,
from the questions that are being asked. I'm always reluctant to read too much into the questions and hesitant to opine on the tone. But I was glad that they were all engaged for sure.
yeah, yeah. Even Justice Kavanaugh, he grilled Paul Clement, petitioner's counsel, heavily right from the outset through the end of time, but then he grilled Mr. Boutros as well quite a
He
bit.
did.
And so you said that each of one of the lawyers had only one sheet of paper?
Yes, yeah. When Paul Clement walked up, I saw just one piece of paper that he had, and I couldn't tell. My vantage was a little bit obscured when Mr. Boutros came up, but none of them came up with a stack of things. They clearly had a mastery of the subject matter.
Wow. Wow. Okay. Last question. I'll get you out of here on this. If the plaintiff wins, then fill in the blanks. If the broker wins, then fill in the blanks. So talk to me about the implications of what will happen if each side wins.
Yeah, sure. So if in fact the petitioner were to win this case, it's going to have a profoundly negative impact on the brokerage community. There are all sorts of policy reasons why that would be the case, but fundamentally, it's going to change the way that brokers operate. At present, there's have a degree of comfort that when they are selecting a federally licensed motor carrier to perform interstate transportation, that they've done their due diligence, that they have met their expectation, and that they've had the protection, they believe, of the federal statute, the F4A, to preempt those claims. So, if in fact these claims are permitted to proceed, we've got a parallel regulatory regime essentially emerging, which undermines the intent of Congress in enacting the F4A. Brokers are going to continue to be named and will increasingly be named in every case involving a motor carrier because brokers play a very significant role in the marketplace. You're going to have small motor carriers that are trying to enter the market who are going to be excluded from the market because, as one of the counsel made the point during the oral arguments, nobody ever gets in trouble for hiring IBM. Go for the largest, most established, longest tenured motor carriers. Small brokers simply can't perform the type of diligence that plaintiffs imagine they can. If the critique is that the federal government isn't doing a good enough job, how can this obligation be effectively performed by brokers who have even fewer resources and don't have the architecture of the federal government at their disposal? So that's the real concern. If the brokers do prevail, and the court rules in favor of respondent, then we will have a more thriving and active interstate transportation market because brokers can now operate knowing what the rules of the road are. They will be able to accelerate and add some additional efficiency to the way that supply chains operate every single day. So it will be a boon to the entire economy. And it will certainly, give brokers peace of mind that they no longer face this type of exposure, as long as they're doing everything else appropriately.
Well, Mark, thank you so much for your time. That was such a very helpful breakthrough. Quick question for you. Where can listeners find you?
Sure. I'm on LinkedIn. I don't use it to a great deal, but I am on LinkedIn and certainly on my website at www.beneschlaw.com. You can find my bio and various publications and articles and the like that we put out.
Great, great. Well, again, thank you so much for your time to help break down the oral arguments and the briefs. This is a very, very important case. And so it was helpful to have you on today to decipher the fact versus the fiction. On the High Court report, we will continue to follow this case closely and any developments that arise. Everyone come to the High Court report and learn about those developments. We really appreciate your time, Mark. Thank you so much. Everyone follow Mark on LinkedIn. Go to beneschlaw.com. Thank you very much. Talk to you soon.
Thanks, Ryan. I really appreciate it.
Yes. See you later.
Bye.